Right. So a contract, here's the I guess the textbook definition of what a contract is. A promise or set of promises for the breach of which the law gives a remedy. So it's not just a promise, right? It's a promise where if someone breaks it, we can do something legally about it. So again, we'll talk about what those terms are in a minute here. All right, so where does it come from? So the first place is common law. If you remember, the common law started in England, and in essence, it was all of these rulings by judges that people kept writing down, and over time, that just became the basis for law. We still have that in our modern system, especially in the appellate system, where when an appeals court or the Supreme Court makes a ruling, right, it kind of stands as the law, because if somebody tries to challenge it, it's like, well, it's already been settled in this case. So that's where it started. And then this restatement of contracts was put together by a group of attorneys and retired judges, where they, in essence, combed through all of the past legal decisions on how contracts work, and then wrote out a document called the restatement, and then they did a second version of it, of contracts, which has, in essence, been adopted by most states as how laws work. They'll just like sort of take that verbiage and put it right into their own laws. Okay. So, and then also a federal law called the Uniform Commercial or UCC, which again was drafted by this national conference. So it's not federal, I take it back. It was drafted by this conference, and then all of the states have just sort of adopted it. It says adopted in whole and part in all states. For a long time, there was like one holdout, Louisiana, I think, who was like, we do it our own way. I mean, how do we do that with a Louisiana accent? I can't do a Louisiana accent. Nope. I was thinking about if I could do it. I can't. All right. So a couple of terms that will help us as we try to understand contracts. The first is that some contracts are bilateral and others are unilateral. Most contracts are bilateral, which means the first party makes a promise in exchange for the second party's promise. Okay, an offerer and an offeree. So somebody's offering you, and then you're agreeing to do some performance, a promise in the way back. So you promise to pay back money with interest, and the bank promises to loan you the money. Would be an example of a bilateral contract, and that really is most contracts. Okay. Because the other one is what's called unilateral. The first party makes a promise in exchange for the offeree's performance. So I guess there's a lot of these too. Drive my car across the country and I'll pay you $500 plus expenses, right? So you're not offering anything back to me except for the performance of what I asked for, as opposed to, you know, offering back to me money or some other thing of value. All right. Another set of terms is express contracts versus implied contracts. So an express contract is really one that is either written or oral, and it spells out specifically what the expectations of the parties involved are. That's express. So express in legal terms doesn't mean fast. It means specifically stated. That's what an express thing is. It's, you know, we say exactly what each person's supposed to do. That's an express contract, as opposed to what's called an implied in fact contract. So it's non-spoken and non-written. If you go to a restaurant, you order food off the menu. You that food. You can't be like, oh, I never said I was going to pay you, right? It's expected that by ordering it and then eating it, you're going to pay for it. Here's a question though. What if you order it and don't eat it? Like, what if they bring it to you and it's not made the way you like it? You have the right to send it back or refuse to pay? Probably. You'd have a hard time prosecuting you for it, because you'd be like, they didn't bring me what I asked for, right? I asked for a cheese crisp and it was burnt. I didn't ask for a burnt cheese crisp. I don't know, whatever. So here's an example. You go to the doctor's office, same thing, right? The doctor sees you and then you pay. Although I've noticed that our doctor now, like, they want payment up front. Makes me feel like they don't trust me. I don't know. but that's how they do it. All right, and then we have what are called quasi contracts or quasi contracts, depending on who you ask. Okay, and they are implied in law. So the last one was implied in fact, meaning based on the things we've done, we've implied an intent to pay or whatever. These are implied in law, and these are things where one party confers a benefit to another, both are aware of the benefit, and retention of the benefit without compensation would be unfair and unjust. These become sticky sometimes. For example, you're stopped at a red light. Someone stumbles up to your car, starts spraying your windshield with cleaner windshield, and then asks you for $2. You have any obligation to pay them? The courts say, yeah, because you should have stopped them. Maybe a more extreme version. You come home from work one day and someone's out there painting your house. You can ask them to paint your house, but you're like, looks pretty good. So instead of stopping them right then and there and saying, I did not ask you to paint my house, return it. Does it fall under these elements? One party confers a benefit to the other. Both of us aware of the benefit, and the retention of the benefit without compensation would be unfair and unjust. This is the sticky point, right? Because you could be like, unfair, I didn't ask him to paint my house. But did you know he was painting your house, and did it provide a benefit to you and you allowed that to continue? Yeah. So these are stickier, but those are called quasi contracts. They are implied in law, not necessarily in fact. In other words, in fact would mean it is normal and accepted that I would be paying for this, like the doctor's office. Here, it's like, well, I never asked for that, but I did gain a benefit from it. And so you have to duke it out over the cost, right? Like, how much should I actually pay you? Probably, you know what a court would say? Whatever the normal going rate for house painting is. So what that means is if somebody is giving a benefit to you of some sort, and you don't want that benefit, you need to immediately, upon your first recognition, your first awareness, do something about it. I probably wouldn't even tell them verbally. I would give them a letter. Well, I would tell them verbally and then give them a letter, right? Send them a letter that says that's probably goes through certified mail that says, I do not have this, I do not want this, and I demand, in essence, that you return my house to its pre-performance condition. And that would stand as evidence that as soon as you became aware of some benefit, you immediately took steps to put it away. All right. Another set of terms: void contracts versus voidable contracts. So a void contract is a contract that can't be valid because it's a contract to do something illegal or against public policy. So with void contracts, neither side can enforce the contract. So like if I agree to buy drugs from Bethany and we write up a written contract because we're stupid, right? And then I deliver the money to her and she doesn't deliver the drugs to me, I can't really go file suit against her in court and be like, didn't deliver on her promise, right? So that's a void contract. Any contract to do something illegal, contract with someone to, kill someone for you, that's a void contract. And that is why, how do those sorts of contracts get enforced? Usually through violence, right? If we made an agreement to buy drugs and then I gave her money and she gave me drugs, it would probably be resolved not through the legal system, but through some other means, right? So contracts are still out there, right? People contract for illegal things. They're just not legal contracts. They're void, but they get upheld in other ways, usually by threat of violence. And honestly, right? That's how the world works. So from a legal standpoint, they do not exist. The court would just dismiss, and then probably send over and be like, these morons are doing drugs and they're selling drugs and they're making written contracts. Avoidable contract is one that is legal, but you contract with one of the party that has the right to end the contract. So a contract with a minor. So if we make a contract with a 16-year-old, that 16-year-old can't be bound by it because they don't have what the legal term is. They don't have capacity yet. You have to be an adult to agree to a contract. So I'll give you a good example. My son used to do like choir and stuff like that, and they would go away to these like choir performances or choir competitions. And while they were at it, the company, there was some company that would like take pictures of the kids, right, and then like sell them packages, and they would give the kids the pictures and then send a bill to their house. In theory, I could just refuse to pay and say, I never agreed to this. The only person you agreed with was my minor son. We want our pictures back. Sorry. They would have no means of enforcing that. Now, of course, there's this moral part of you that's like, it conveyed benefit on me, but in this case, they made an agreement with a minor, which is avoidable. Other people that lack capacity are people who do not have sufficient mental capacity, whether because a court has judged this person is not, they have low IQ or they have some other sort of special need or something, where they can't make it. Minors, and that's about it. Everybody else can make a contract. Okay. And then finally, an executed contract versus an executory contract. An executed contract is one in which all the promises have been performed by the people, versus executory, which has been entered into but not yet performed. In other words, we've agreed to it, but we haven't completed it, right? Which happens. That's just part of the normal flow of things. And then some contracts can be partially executory / executed if, say, one side has performed. So if I hire you to paint my house, you paint my house, and I have 30 days to pay you, we would say partially executed. Portion and just waiting on me to complete mine. And again, if it's within the terms of the contract, they have 30 days to pay. There's nothing wrong there. Nobody's doing anything wrong. That's just the state of it. So sometimes when you see legal documents written up, they'll talk about the contract being executory or executed, or whatever. All right. So here's what we have to do to form. I was going to say to formate. That's not correct. To form a contract. Okay. So there has to be an offer. If there's no offer, then there's no contract. There has to be acceptance. So I can't like, okay, I'll sell you my car for this much, and then she never, and then the next question is, do we have any defenses? In other words, now Al wants out of the contract, or maybe I do. Maybe Al wants the car, but I'm like, oh, I had someone else who wanted to buy it for more, right? So the defenses I could try to use to get out of the contract could be undue influence. Probably she could use the defense of undue influence on her teacher. She could say, I felt obligated to enter into this contract with him because he controls my grade, because, or whatever, right? Whereas it would be harder for me to argue that. Like, I guess maybe if we found out that like she was going to go to my boss and her dad knew my boss and she was going to get me fired, that's the idea of what undue influence is, right? When someone enters into a contract in a less than free and open way, okay? Second defense could be misrepresentation, fraud, or I lied about it, or this car was, in perfect, she got it, it had problems. Okay, it's like I wouldn't have agreed to buy it for that much if I'd understood the problems that you didn't clearly. And then fraud would be, instead of me misrepresenting, now I outright lie to her. And duress forces someone into something, right? So it's kind of like an extreme version of undue influence. Like, you're going to agree to this or your mother's going to go missing, or something extreme like that. Think about it. Duress sort of makes, it's a defense. Capacity, they're dealing with a person here who has the mental capacity or the legal age capacity to make the contract. And then illegality. And even the law even recognizes mistakes. For example, anybody see this? There was a news article about a kid who ordered like $3,000 worth of stuff from Amazon, from their mom's Amazon, you know, and because it's linked up to your pay, Amazon could be like, sorry, but that's not Amazon's model, right? They take returns and stuff. But in essence, in some other relationship, you could see somebody being like, I'm not giving you your money back. And so you could probably go to court and say, this was a mistake. This was a kid was able to get on the computer when I stepped away to go to the bathroom and hit send or whatever. Okay. So those are the defenses to a contract. If we have a defense, we can have a void contract or avoidable contract. If we have no defense, then we're down to the last one, which is writing required? So if it's a verbal contract, but by state law, a written contract is required, then we may have one last defense. So for certain things, real property, like land in Arizona, you have to have a written deed of sale. So we can't just do it on a spoken handshake. So if we've spoken and agreed and everything, but never finished the deed, I can still back out. That's why usually there's some sort of contract in place even prior to the deed. And usually that involves what's called earnest money, which means if I back out of this deal, I'll forfeit a certain amount of money. Also vehicles, they have a written thing where you have to change the what's it called, the title to the vehicle over to the other person. So if we have an offer, acceptance, consideration, we don't have any defenses, and writing is not required, or if it is required, we have a written document, then we have a valid contract. Okay. And again, back to the idea of good fences and good neighbors, this is going to allow, you know, if we're doing business together, it's going to allow us to keep doing business together because we understand the terms and we're going to get along well. If I'm doing business with Boaz, what I want is a mutually beneficial, him to keep selling stuff to me at a certain price and I'll keep buying it from him. It's good for him because he's getting paid, and it's good for me because I'm going to have the product I need to sell my customers. That's all I want. And so if we can take care of all of these little details and not have constant fights over that, we're going to have a good relationship. Start to just like ponder what our modern society would be without good functioning contract laws. It's everywhere, and we need it to be everywhere, or else we'd have some real problems. There's just the defenses, which I already went through. So, other things that we might decide in a contract: when is performance due? We have conditions precedent. That pre means before. Okay. We have conditions concurrent, which means at the same time, and conditions subsequent. So a lot of times what we're saying is, first, you're going to do this. Precedent, right? Then we'll both do this. And in the end, then this will happen. Those are the conditions. Because if you think about it, sometimes we make an agreement, it's pretty easy. Like, I'm just going to sell the car to you and you're going to give me money. But someone could ask, wait, are you going to deliver the car first and then I pay? Or do I need to pay before you deliver the car? That's where these conditions come in. And as with more complex things like building a home, right, where there's all these different subcontractors that will be coming in and doing work, it's helpful to say, once we hit this point, then you're going to make a second payment to me. Like usually with contractors, they'll get paid a third of the amount up front, a third of the amount upon some level of completion, and then a third of the amount upon final completion or whatever. So those are what we mean by performance. And then things like standards of performance. If I say you're going to paint my car for me, is it reasonable for me to expect you would paint it to some certain level of professionalness, right? And not just like look like some kid rolled a roller brush on it. So again, we might write that up in the contract that there'll be some certain standard conditions. Typically, if you don't agree to specific standards, the court's going to say, we're back to like the prudent person principle. Would a normal prudent person think that this was acceptable? And this is why if someone burns your food at the restaurant, you can send it back, because a normal prudent person would not think it was okay to give you burnt food and expect you to pay for it. right? Or to have a 3-year-old spray paint your car and then expect that that's what was meant by. And usually it's not even contracts, it's just the desire to stay in business that leads people to contract correctly, right? You get a reputation for always giving people burnt food, they're going to stop going there. And so, anyway. So occasionally, the law recognizes that we can excuse a contract. The biggest reason is what's called impossibility. So we agree to something, and then, I agree I'm going to build you this home on the beachfront where you own property, and then a giant storm comes and just wipes out and leaves just like a sandbar there that's not safe for building on. Probably we can go to court and say, what we originally agreed to do, I can't do because there's no longer a suitable place to build a home there. That's impossibility. Stuff like that happens, right? Where we can't do it anymore. Oh, that's actually their example they have too. I didn't look at that. I just made that up. So, and then there's commercial impracticability. So the basic assumptions we sort of based our original agreement on are no longer the case. So when I agreed, so sometimes they call this what's called a force majeure clause, which kind of means like an act of God. So things like wars, embargoes, depressions, COVID-19, those like, so I agreed to purchase a certain amount of this product from you prior to COVID-19 hitting, and then COVID-19 hit and everything shut down. That might be a reason for me to be able to back out of it and say, like, I can't do this anymore. Of course, I don't want to do that because I want to maintain a good relationship with you. And so we try to, rather than going to court, it'd be better if we got together and come to an arrangement of some sort, right? All right. And then there's what's called substitute performance. Sometimes when we can't perform the contract the way we originally agreed, can we come up with some other solution like novation, which is we agree to substitute party. Like, I agreed to build this home for you. I've had these financial situations that won't allow me to do it, but I know a really great contractor here who can step in and do that. And if all parties can agree, in essence, one contract, the party assumes the other. Or accord and satisfaction, where we just say, okay, we know we can't complete this the way we originally planned to. We make an accord, an agreement, to discharge the contract with something. Sometimes it's kind of like an out-of-court settlement, right? Like, I can't build you the house, but I'll be willing to give you back your $10,000 deposit, and everybody's good, and they leave. And that should be just about it. Also, recognize if somebody does break a contract with you, you can have what's called compensatory damages, which means they have to pay to make you whole, whatever the costs you were. There's not usually punitive damages like in the torts, but it's just like, if they cost you $10,000, they're going to have to pay the $10,000 back. That's what we mean by compensatory. And then incidental damages, like, if I have to pay my attorney's fees, or if in addition to my car, maybe they're going to pay the cost of having to go find a new car or things like that as well. And that's it. So there's contracts. Sorry we got such a late start, and hopefully it makes sense. Have a great day. We'll see you on Wednesday.